Thank you all. Well, I want to welcome everybody to another edition of Public Leadership Institute's Policy Leadership's online webinars. We bring these sessions every other week and to bring activists, policymakers, concerned citizens together to learn new skills, talk about new ideas, talk about advocacy around issues of shared importance. I want to thank everyone for being here today. Today's topic, we're going to be discussing legislation to protect internet privacy. My name is Dave Woodward. I get to be your host today. I'm the National Network Director with Public Leadership Institute. I'm also a local county official and a former state legislator, and when I was in the state legislature, technology issues were one of my focal points, and I'm very excited to hear what our panelists have to talk about and discuss today. For those who are joining us for the first time, the Public Leadership Institute is a nonprofit, nonpartisan policy and leadership center really focused on bringing public attention to key issues like the one we're talking today, particularly issues that deal with equity and justice, and as well as working with public leaders to improve the economic and social conditions for all people. You can get more information about us at www.publicleadershipinstitute.org, where you can also gain there is a number of publications that we put out, many that are on your screen right here. You can download for free and encourage you to do so, as well as information recordings about today's presentation for reference at a later date. Again, that's www.publicleadershipinstitute.org. Everything about our organization is there. Just one quick little housekeeping matter. We really want these sessions to be as value added as possible to, and we want to make sure everyone who's joining us is getting everything from the presentation they possibly can to help support their work, or be at least directed to where they can go to get more information to build on what's being presented today. To that end, we've got a number of ways for you to participate. The first being, if you have audio capabilities from where you're joining us, if you click on the hand icon on your GoToMeeting control panel, you can I can unmute you and you can ask your questions directly of our panelists. We realize that people join us from a variety of places, so you can, and if you don't have audio ability from where you're joining us, whether it's from your smartphone, your iPad, your computer, what have you, feel free to type questions in the question bar, and when we pause for some questions, I will try to get through as many of those as possible. You can always email me directly at dwoodward@publicleadership.org, and if there are questions as it relates to this topic and follow-up, I will definitely make sure that you get your question to the right person to get it answered. So we really do want to bring your voice and conversation into this, so please get those questions working, thinking, and we'll put it up there. So like I said, we've got a tremendous number of panelists today with a host of experience. I'm going to start off with Representative Ann Williams, who's currently serving her 4th term as state representative in the 11th District on the Chicago's North Side in the great state of Illinois. She's a strong advocate for reproductive rights and was a leader in bringing marriage equality to Illinois. She sponsored and supported numerous legislative initiatives pertaining to privacy rights and data privacy. Representative, thank you for being with us, taking time out of your schedule to be with us today. We have Peter Hanna, is a privacy, data protection, and intellectual property lawyer, and his broad and extensive experience advising clients on the most complicated issues at the intersection of technology and the law. He's testified before lawmakers and presented on significant data privacy and security trends across the country and abroad, and Peter is the founding member of the Digital Privacy Alliance. And Peter, thank you for being with us. We also are joined by Matt Erickson, as the Vice President of Engineering at Spider Oak, where he builds state-of-the-art online communication tools that are secure and private. He also serves as the Industry Outreach Director for the Digital Privacy Alliance. In that role, Matt brings together various sectors of the tech industry that represent user privacy and enables them to speak with one voice in legislatures across the country. And last but not least, we have Michelle Demouy. Michelle is the director of the Privacy and Data Project at the Center for Democracy and Technology. She advocates for individual autonomy and control over personal data through privacy rights and protections in legislation and regulation. Michelle also chairs Center for Democracy and Technology's Internet Privacy Working and Healthy Privacy Working Groups. Both are platforms for bringing people together from diverse stakeholders to discuss the most pressing issues in technology policy today. Like I said, we've got the state-of-the-art experts around the country that are joining us here today, and I want to thank all of you, all our panelists, for being with us today. And like I said, today's topic, legislation to protect internet privacy. And to start us off, I'm going to hand over the presentation to Peter.
Thanks, Dave. Can everyone see the PowerPoint that's loaded up here?
Did you take control of the screen?
1 second.
I don't you have to click accept. There you go. Yes. Perfect.
Great. Well, thanks for the introduction, Dave, and nice to be on the panel and to join everyone in PLI, and thanks for the honor of presenting today. So I'd like to begin by providing an overview of the collection of personal data that we've seen by companies and private organizations, and I'll talk about that for a while. Then I'll discuss kind of the emerging technologies that are used to collect certain sensitive data, including geolocation and biometric information. Then talk very briefly about the legislation that we've seen at the federal, state level, and also very briefly at actually the global, on a global scale, and kind of lay the stage and the framework for why the privacy debate and privacy legislation debates have been moving out of the federal government into the state houses. I'll touch briefly on the core principles that animate and underwrite, like, and underline all the key privacy legislation that's out there. And then I'll pass it on to Representative Williams, and she'll talk about the geolocation privacy legislation and get into a case study. So without further ado, just to dive in, personal data collection is happening, as we all know, at a greater and greater rate. Companies are collecting and processing more personal data than ever, and that's due to a few factors. The rate of data creation is increasing very rapidly. We have many more devices in our lives that are generating, storing, and communicating data to be processed. I think 5 or 6 years ago, none of us would have expected to have, a smart computer we could talk to in our homes that also is able to communicate with a server in a third party's possession, but now it's become commonplace. Health data, financial data, almost all of our communications are going digital, and the Internet of Things is becoming more and more visible and more of a permeating force in our lives. I work with a range of clients, and some of our clients have what we would call like dumb devices, or devices and products that are not connected in any way to the internet and have no sensors at all. And they see the trend of making their dumb devices smart. And there are a lot of, it's a lot easier to do from an engineering perspective than you would think. But of course, there are legal ramifications and legal issues to consider when, a dumb device that no one would ever have expected to collect data of any kind now is collecting the data and transmitting it to another product or another ecosystem entirely. So we're moving towards a system where everything is digital. That is also driving an industry that is becoming, with every passing day, more and more prominent, and it's referred to as, just a shorthand, big data. And it refers to the process of very large data set analytics. It is one of the fastest growing industries today. There are data brokers whose entire focus is to collect, parse, process, derive trends and patterns from very large sets of data that they acquire from all the services that we use day in and day out. And the focus here is, again, on aggregating, analyzing, and commoditizing personal data and trends so that there could be new insights and ostensibly creation of better and more enriching products and services from that data analysis. the impacts are not very, they're not invisible, but they're not very apparent at this time of having the back-end big data work underway. One way that we see it is, I invite you all to go to your Amazon homepage, or go to Facebook, then go to your email, and then go onto Google, search for something. You will see that there are communications across the different websites, across the different services you use, so that certain things that you searched for one place might pop up somewhere else. And this is strictly or almost exclusively in the advertising space. But when I talk to you guys a little bit later, we'll discuss how the private company data collection can have a much more dangerous or even nefarious effect when those connections that are made right now strictly for advertising begin to be made for giving you political news and other things that you wouldn't want curated that way. So where is this coming from? Why is this happening? Well, the network is increasing, and we have data across pretty much everything. And it's leading to this really complicated ecosystem that kind of exists beyond specific regulation or legislation. And lawmakers and very vocal advocates in the data privacy space have said that the Internet of Things, which we'll talk about in a moment, is creating a really unwieldy ecosystem across different industries and different spaces and different parts of the world. It's really, really hard to regulate. And although there are lots of benefits that should inure to the customers and the users, there are a lot of risks too. So we have devices that have real-time sensors on basically everything: your phone, your Fitbit. I saw a jacket recently that had an LED embedded that would light up when the weather was, when rain would be predicted. We have social media data aggregation occurring every time you log into Facebook, and log into any social media site. We have organizations moving to cloud computing and doing more and more with our data that we entrust to these organizations on a remote server that, should it go down, might, depending on the service, might deprive us of access to it. Of course, the explosion of mobile devices continues. Data brokers and big data analytics are working hand in hand to create new revenue streams and new insights from data aggregation. The Internet of Things is, for those who are not familiar with the term, the large-scale ecosystem of devices that have the ability to communicate and have a sensor. That's sort of a quick and dirty definition. The longer definition includes that each device should have its own address, so specifically, that's your Fitbit, that's your iPhone, etc. But it includes everything. It includes your, Amazon Alexa. It will soon include many, many cars. It will include anything that has an internet connection and has the capability of measuring a data point and reporting it. And as we see that microprocessors have gotten very, very small, very low energy, we are making many things that were historically or traditionally dumb smart, and the Internet of Things is exploding. And there's a lot of data for companies to mine from the Internet of Things devices, and correlations to be made between devices and among devices and among different demographics who use the same devices and different devices. All that is creating leading to a pace of technological change and advancement that has outpaced the law, has outpaced legislation, and we'll hear more about that later, of course. But it's also kind of blind to what just some very, very basic estimates of what the environment will look like in 2020. So I just wanted to provide some estimates of what we see this leading to in 2020. So by 2020, 40% of all personal data is expected to be collected from sensors on devices. That's going to be 50 trillion gigabytes of data processed. There will be 25 billion internet-connected physical devices. Again, that includes everything we've talked about already. This will create a lot of real market opportunity and a lot of revenue streams, because there's an expectation of 300 billion to Internet of Things product and service suppliers, and that's just the dedicated IoT suppliers. But that's ultimately 4 trillion in revenue to be realized across all industries. So when you sweep in the non-Internet of Things dedicated companies and organizations, the car makers, the computer makers, things that I'm not even thinking about right now, that's $4 trillion by 2020. So before I go any further, I just wanted to point out that I'm going to talk briefly about a couple of different legislative frameworks and set the stage for Representative Ann Williams to talk about the geolocation privacy legislation and the public response. And we're not going to spend too much time on global privacy rights, but I did want folks to see what's out there. So we have three basic privacy models that exist in the world. In the US, we have a sectoral model. Privacy laws respond to very specific risks and concerns. You've all heard of HIPAA. That involves health data. COPPA, that's children's data. State laws vary widely. Among the 50 states, I think 48 at this point have breach notification laws that require an organization to follow a set procedure if there is a data breach, and no two laws are alike. So that is what we have here in the states at the federal level, and of course the state level you have also disparity among the states with respect to which privacy torts and which specific privacy laws they have in place, notwithstanding data breach laws. In the EU, for many years, there's been the comprehensive or the umbrella model, which basically is a very, very comprehensive law that covers to any collection or any processing of personal data. In the US federal regime, for the most part, most laws require you to basically, you have to opt out. You have to take affirmative action to opt out of having data collected, your personal data collected. So you are by default opted in. In the EU model, it's the other way around. You must affirmatively opt in, and by default, you're opted out. We don't need to talk much about the APEC regime. It's generally moving towards comprehensive. So there's already a comprehensive data privacy set of laws in the EU. It's the Directive 95/46/EC. It will be replaced by the GDPR, which begins enforcement in May 2018. We don't need to go into much detail here, but I do want to point out that this is where European citizens and European data subjects' rights, this is how enshrined they are, and of course the privacy right is enshrined in the EU Constitution as well, in comparison to what we have here in the States and the very different situation we have here. So the second bullet point here about unambiguous consent, I think, is really important. Under the GDPR, unambiguous consent is required for data use and collection generally, and explicit consent is required for data transfers to other organizations and downstream sale and transfer of data. I want to point out one other thing. The GDPR, unlike its predecessor, has very severe penalties. Penalties that go up as high as 4% of the annual global revenue of a company, or 20 million euro. And the GDPR also applies extraterritorially. You're not going to be safe if you're dealing with European data subjects' personal data and you're here in the States. It applies wherever the data goes. In the federal system here, we have, again, a sectoral model. So we have a hodgepodge of different privacy laws and regulations. And again, I don't need to march through them, but some of these may be familiar to you: the Fair Credit Reporting Act, the Children's Online Privacy Protection Act, the ECPA, the TCPA, which deals with telephonic communications, Video Privacy Protection Act, which was passed when there was a concern that someone's video rental history at Blockbuster could be sussed out and used against them at some point, but is now being used in the same in the context of watching YouTube videos and other videos. But you can see that on the federal level, our privacy laws, at least as far as congressional legislative actions, have focused on sectors, usually in response to some sort of really difficult situation or some need, and they've been reactive in the way they've been passed. In fact, the TCPA and Banking Privacy Act were passed in response to a Supreme Court decision that basically said that data that you entrust to a third party, like a bank or a telephone company, is not data subject to a reasonable expectation of privacy. So that data, you shouldn't be surprised if that data can be recovered by the government on merely a subpoena rather than a warrant. Congress acted quickly after that Supreme Court decision. Those two Supreme Court decisions came down and passed those laws. Here on the bottom, you see 81 Fed Reg 87-274. That is what is now known as or has been referred to as the FCC privacy rules, and those were that was the rule that Congress just approved a joint resolution to disapprove of, and President Trump also acted to, he signed that resolution and will not go effect. It was scheduled to go in effect a little bit later, but Michelle will talk to you about what these privacy rules did. I can tell you in essence, and many of you probably already know, it prevented ISPs from using your data and selling your data, that basically your internet activity, to other parties. It would have prevented, but it did not. It had not gone into effect. It now will not go into effect, and it's one of the many factors that I think is really moving this issue into the state houses now. Existing state privacy laws really run the gamut. Of course, we mentioned breach notification laws, and there's a bunch of specific privacy torts, but again, these vary very widely from state to state. Shine the light laws, right of publicity laws that prevent anyone from using your likeness, voice, etc., without compensation. Invasion of privacy, of course, even common negligence theories have been sufficient to bring causes of action, to support causes of action where there are privacy or cybersecurity violations accused. Right to know laws, we're seeing more and more in the legislatures, and they really get after a very, very simple concept, which you'll hear is a theme of, hopefully throughout this presentation, which is transparency. You should have a right to know what a company that you've entrusted your data with, what they're doing with that data. And we're seeing legislatures, including the Illinois legislature, try to get a right to know state law in the books because there has been very, very little action on the federal front. One very small footnote is Senator Franken did introduce a Senate bill, I think in 2014, that would have protected against geolocation tracking without consent, and that has basically languished. It was reintroduced, I think, in late 2015, and there it remains on referral to the Judiciary Committee. We also have, of course, Biometric Information Privacy Acts and right to privacy in the workplace laws, but these are, again, they don't get to the much broader and more comprehensive concepts of transparency and notice that we see enshrined and really built in and woven into the European and comprehensive privacy laws. I wanted to just point these out because they may be unfamiliar to folks who are not don't have much privacy practice experience. But these were promulgated. The U.S. The Fair Information Practice Principles, or FIPS, were promulgated by the FTC in the 70s, and these were basically eight principles that should be underpinning any interaction between a company and a consumer. And I wanted to highlight transparency because transparency is really, it's almost the bare minimum, but it goes such a long way. When you have transparency here, there are very few restrictions in the United States on what you could do with someone's data once they give you permission to do what you want with that data. But there are not enough laws that require transparency and require notice and require consent, that additional step, but again, at the bare minimum, to make sure that consumers are at least aware, at least they're signing something, they're giving you rights to their data in a way that they understand and they comprehend, and that's what transparency is really all about. And I cannot emphasize enough, this is really the bare minimum that you could ask for. So with that, I think this is a good moment to pivot to Anne and pass the baton to her so she could talk about legislating privacy in the states and give us a case study.
Am I ready? Good to go?
Yep, we can hear you.
Okay, hi there everybody. Thank you so much for being here today. Thank you for everyone that organized this. I am very excited to be here. I'm very excited about this issue and excited about the bill in Springfield that we just got out of the Illinois House, and now it's under consideration in the Senate. So I don't have a lot of formal remarks prepared, but just wanted to provide a kind of an overview on some of the dynamics that, I think this angle's a little better, that came into play when we worked on passing this bill. I've often worked on privacy-related legislation, but generally it was from the perspective of protecting privacy from law enforcement agencies or government entities. I've worked on a few bills, both as a staff person and also as a representative, on bills dealing with personal information protection in conjunction with the Attorney General's office, as well as an internet security breach legislation that Illinois passed a couple years ago. But the context of this bill was much different. This was a direct protection of consumers. And that was a little bit of a different direction for Illinois, so a little bit of a new area. This bill, my bill, the Geolocation Privacy Protection Act, was pretty simple actually. It just provided that no private entity, and I'm reading now, may collect, use, store, or disclose geolocation information from a location-based application on a person's device unless the private entity first receives the person's affirmative express consent after providing clear, prominent, and accurate notice that informs the person the information will be collected, used, disclosed, what the purposes are for, and an accessible means to access the information. So it's pretty straightforward, but gosh, you wouldn't think so based on the opposition that very quickly and very significantly arose no sooner than the bill was introduced. I think the bill would have had a good chance of being successful normally, but it might have been a little bit of a tougher road to get the support of all of my colleagues, but for the fact that President Trump made the commentary about and took action on the items that Peter was mentioning related to the disclosure of private information, the protections being rolled back. I started to hear from constituents, see Facebook postings, and get emails about this issue right away from groups that had organized in the wake of the election and were fighting back, resisting some of the items on the Trump agenda. But the interesting thing about this topic is privacy is not a partisan issue. It impacts people, and people are interested in keeping their data private regardless of whether they're a Republican or a Democrat. So between what happened on the federal level and the idea that it's not really a partisan issue, and people, when confronted with privacy breaches or privacy or information as to how their privacy is being collected and used, I think most people are not aware of the significance at which their data is being collected, used, and monetized. And when they are made aware of it, they often don't like it and want to take action, and they expect government to take some action. And I think in many cases presume that we're already taking action to protect the privacy. Many people are shocked to find out that there's no federal law really having the adequate protections in place. So right after the activity on the federal level, there was a New York Times article that came out that basically said the fight for privacy is now in the hands of the states. So this was extremely helpful for the initiative that I was working on, as it generated some public attention. And the Chicago Sun-Times also weighed in support, which is another very helpful item. I don't think those two things might have happened had this not gained so much attention on the federal level. So my bill was one of a package of 2 items that we are pushing in the General Assembly. And the other item, it was referenced earlier by Peter, and that deals with a right to know statute. That's a bit more contentious than mine because it's much broader, but we're fighting that both on the House and the Senate level. Thought it was helpful to kind of package these bills and make it a larger discussion about privacy. Because when you talk about geolocation and the impacts it has on your privacy, you naturally expand the conversation to how else your data, your personal data, is used. And it really is an issue of education and awareness, first and foremost, of not just the public, but your colleagues. So as you can imagine, big data, all that makes up big data, opposed the bill very strongly and very in mass, both my bill and the other bill, the Right to Know bill. So this was something that we had to contend with from day one, was kind of a continual, and I'm sure if you're in the legislature anywhere you understand this, there was a continual dynamic where we'd meet with the opponents, ask for tangible suggestions on how to make the bill better, and really nothing would come up. We'd have multiple meetings with multiple parties, again, in the category of big data, and we're very, and all these meetings really did not bear fruit, and the industry was not willing really to work with us to negotiate a more favorable bill. The one issue that they honed in on quite a bit was the issue and the inclusion in the initial legislation of a private right of action, which of course would allow the private bar to go after companies who violated the laws. Now, personally, I'm very supportive of this. I believe the private bar has a strong role to play in enforcing rights of people that otherwise won't be able to have their rights enforced, and against the big bad companies that often have a lot of resources to avoid liability. But in terms of the conversation, the private right of action was a continual theme that we heard and was a drumbeat that continued throughout the discussions and negotiations. In private discussions, some of the industry representatives suggested that they were interested in the idea of maybe using Illinois as an opportunity to create a model, if you will. We are one of the first states, actually the first state to pass a Geolocation Privacy Protection Act or anything of that nature. So why not start in Illinois? We're a big state with a lot of tech companies here, and maybe this would be a good opportunity to develop a model that could be used the rest of the state, find some middle ground that would accommodate both the needs of our citizens in terms of their privacy interests and also the companies who deal in big data. But that was some private discussions, but when I had the meetings, that wasn't a direction that ultimately the big guys at the top of big data wanted to go. And my belief is they are looking to continue to postpone any regulation and avoid regulation as much as they can. We heard a lot of conversations in these negotiation sessions about what the industry is already doing to protect privacy. And certainly there are some good actors that are very responsible with data, but there's an array of how the companies treat data. So not everybody is equal, and certainly some companies provide very strong privacy protections, but others don't. The argument we did consistently hear, though, was that the industry was interested in self-regulation, and we're in fact doing a great job of that already. But I think, again, hearing from members of the public, I think there's a very basic interest and a responsibility of us as legislators to ensure that we provide the regulation. I made a joke throughout the time working on this bill that, at least in Illinois, the statute books are filled with regulations and restrictions on companies that I'm sure would rather be self-regulated. So we ended up, as a practical matter, removing the private right of action and limiting enforcement to the Attorney General and state's attorneys. I felt that this was still a very important and significant piece of legislation, regardless of whether we had the private right of action, because we got the fact that companies have to notify the public when they're using their data and tracking their locations. And that in itself was a huge victory. A lot of the private right of action discussion really was about setting up what in Illinois and probably many other states is a classic battle between the trial bar and industry and business. And that really isn't what this bill is about. There were a lot of business interests in support of the bill, but I think the opponents were comfortable making that argument. So when we removed the private right of action, I guess you'd think everyone was on board. Well, of course, that wasn't the case. The opponents fought till the very end and continued to think of various reasons and problems with the bill. And again, continued discussions and soliciting opportunities for input and amendment just were met with no interest, and kind of leading me to, again, to the conclusion that there's really no interest in regulating unless they absolutely have no other option. So in terms of the moving forward on this issue, I think, like everything else, legislation that deals with the protection of data, private data, is going to be challenging, and it will take time to pass any of the pieces of legislation. The big problem with that, as opposed to many other areas, is that the industry and the way that technology is used and how much data, as Peter pointed out, is being collected, monetized, and sold, used, everything else shared, is just incrementally moving so much faster than the law ever will. So I think it presents policymakers with a real quandary. What do we do to make sure that consumers' information is protected while still allowing technology and the many ways that we use technology to flourish? In most cases, we say look for a balance, but clearly we're not balanced here. This is one small step the bill that I passed, and I'm hopeful we can get it through the Senate. We'll see what our Republican governor has to say about it. Although I will point out, this issue, again, is not really a partisan issue. It became so in Illinois to some extent because it was portrayed, and the narrative was this is business versus the trial bar. But at the end of the day, I was able to get 5 Republican members to vote for the bill, and I heard privately that many others were interested in the topic. So I feel positive about continuing to move forward with efforts to protect the privacy of individuals. I hope that those of you who represent communities in other states will do so, and then that will give added momentum to all of us to continue to work on protecting data privacy. Again, thank you for your time. Good luck, and I'm hopefully very easy to find. And if there's any questions you have for me, or thoughts or ideas, I'd love to hear from you. Thank you so much.
Thank you, Representative. Thank you.
Yeah.
Peter, who should we go to next?
I think we go to Michelle next.
We'll go to Michelle next. Perfect. Michelle, you there?
Yes, I am.
Perfect.
Hi there, everyone. Thank you very much for having me today on today's webinar. I really appreciated Representative Williams' comments, too. I think she really hit the nail on the head on a lot of issues. And in case you aren't familiar with CDT, we are the Center for Democracy and Technology. We're a digital rights advocacy organization in Washington, D.C. and in Brussels. And our work, excuse me, focuses on imbuing democratic values online through balanced policy and through technology tools. And we have projects at CDT addressing free expression, government surveillance, privacy, internet architecture, and open internet. So needless to say, we've had quite a busy year so far. I'd like to start by giving a quick baseline on how the FCC's broadband privacy rules came about, what the rules would have required, and the state of play right now. Then I'll talk about how the states have tried to tackle broadband privacy and touch on a couple examples, and then give an overview of some of the challenges that you may face as you're trying to implement these bills. So just to take a step back to give a little bit of an overview, the internet service providers, or ISPs, offer consumers high-speed continuous access to the internet, typically through cable, telephone, wireless, fiber optic connections. We're talking about Verizon and Comcast and AT&T. And I want to make the distinction that they're different from entities like Amazon and Facebook, which don't provide connections to the internet but are internet services. So cloud storage and messaging, news, video streaming, online shopping, those types of services. And as Peter touched on, ISPs handle all of their customers' network traffic, which means they have an unobstructed view of all of their unencrypted online activity, all of your unencrypted online activity, all the websites you visit, the applications that you use, along with lots of other information. If you have a mobile device, your ISP can track your physical and online activities throughout the day in real time. So it's sensitive. And most people have a pretty limited choice when it comes to choosing who their ISP is. And I'm sure everybody has a personal experience with, that there are maybe one, maybe two options at most in your community. And this also makes them distinctly different from entities like Google and Facebook. Well, in 2015, this all changed when the Federal Communications Commission issued the Open Internet Order, which reclassified ISPs, which they actually called Broadband Internet Access Service Providers, or BIAS providers, you might see that. They were reclassified as telecommunication services, which subjected them to the Common Carrier Regulation at the FCC under Title II of the Communications Act. Among other things, Title II requires telecommunication services to furnish services to customers upon reasonable request and prohibits unjust and unreasonable discrimination in the services that common carriers provide. Title II also provides that telecommunication services have a duty to protect the privacy of customer data. So the first is net neutrality, and the second is broadband privacy. And the broadband privacy rules released by the FCC in 2016 were fulfilling this congressional mandate to ensure that the common carriers were protecting the confidentiality of their customers' information. This was something they had to sort of fill in the blanks for. There was this mandate, but it wasn't clear how or what the provider should do. And so there was a long process with public comments where the rules were very carefully and thoughtfully laid out and balanced, in my opinion. And what they required were customer opt-in for the use or sharing of sensitive information for purposes any other than the providing of the service. And there were other exceptions also built into the rules, including for marketing telecommunications related services, which you might know as bundles. The rules also defined sensitive information, which was important, and it included things like web browsing history, app usage history, health information, and geolocation. This is something that was very new, had not been done before. Bias providers were also allowed to use an opt-out for non-sensitive information, which means they could use information that was considered non-sensitive by default unless a customer asked them not to. They also had to institute reasonable data security and data breach notification rules, and that is all that was defined, so it gave them wide latitude there. They were not allowed to do certain things, such as offering a take-it-or-leave-it offer to customers regarding data sharing, so they couldn't say, if you don't agree to let us use your data, you don't get to use this service. There were also heightened notice and consent requirements for the pay-for-privacy type offers. And the rules importantly recognized the special role of bias providers in facilitating access to the internet. They are the gatekeepers to the internet and this broad view that they have into our lives, into our online activities. And as I'm sure you know, or you may have heard, that in March of this year, Congress passed a Congressional Review Act resolution to repeal the rules despite huge public outcry of the kind that we hadn't seen in a while. So at this point, broadband providers still fall under 222, which requires common carriers to protect the confidentiality, but they don't have any clear rules anymore about how to comply with this. And you may have heard the telecom industry argued frequently that the FTC, the Federal Trade Commission, should be the agency to regulate broadband providers, as they have some purview over privacy and have often brought enforcement cases related to it. But this argument falls short because the FTC does not currently have the authority to regulate bias providers. Regarding data privacy, in Section 5 of the FTC Act, which is what gives the agency its authority to enforce against unfair and deceptive trade practices, it includes an exemption for common carriers. This is truly important because you may hear this argument over and over again. So this is a giant gaping hole. The acting FTC chair, Maureen Ohlhausen, has said that she wants to work with Congress to repeal the common carrier exemption, which would give the FTC the authority. And also the FCC chairman, Ajit Pai, has issued a notice of proposed rulemaking recently to undo the Title II classification. So they would no longer be common carriers. And also there was, I think it was Senator Mike Lee introduced legislation to repeal the Open Internet Order. So there's a lot going on the federal level. And further complicating this, just to give you kind of the full picture of what's gone on and sort of all the complexity of this, in August 2016, there was a decision of the Court of Appeals for the Ninth Circuit, which interpreted the FTC's common carrier exemption as including all activities of any entity designated as a common carrier, even those activities that are unrelated to the entity's common carrier business, and which otherwise would be subjected to FTC jurisdiction if they were carried out by a separate entity. So if that ruling stands and it's adopted by other circuits, and also the FTC is currently seeking a rehearing on that, the FTC suddenly might find itself responsible for regulating a host of non-common carrier related business activities merely because they're provided by entities that have been designated as common carriers. So it's confusing and it's a little nuts. That's the technical term for it, I think. So a host of states have introduced legislation on broadband privacy. They've heard from their constituents loud and clear that they did not like this. You know, a lot of people in Congress, a lot of members of Congress have really started to take notice of the fact, sort of maybe late to the game, that people really care about their privacy, and they really are upset by the repeal of these rules. So you've had rules in Montana, Illinois, New York, Connecticut, Wisconsin, Hawaii. Tons and tons of states are trying to enact this, and maybe some of you are thinking about doing it. So many of the laws, just to give you an idea of the flavor of some of them, they echo the provisions really of the FCC's rules. So they mandate that ISPs get affirmative consent from customers before they share the personal data, and many of them also prohibit them from ISPs from adding surcharges or denying service to customers who opt out of data sharing. Those are two of the most common. Some states have taken the approach of implementing rules through their franchising authority, which under the Cable Act allows states to regulate the practices of cable providers, including cable broadband and fiber. I'll get into in just a minute where there are some questions related to that. There are other states that have added amendments to spending bills related to broadband access, and they include provisions that require providers to get permission from customers before using their personal information, so very similar to the rules. And just to give you a couple examples to give some context to this, in New York, where ISPs are regulated as a public utility, legislation was introduced that would prohibit them from selling browsing history and other personal information to third parties. In Wisconsin, legislators amended a bill funding an expansion of rural broadband, interestingly, requiring ISPs to get permission and restricting them from denying internet services to customers who opt out, again, reflecting some of those rules. Montana used a budget provision to bar ISPs from being awarded state contracts if they collect data from their customers without consent. There's a couple of different models of how this has occurred, but there are some hurdles here, and I want to just raise them. There aren't a whole lot of solutions, but there are some ideas, and groups like CDT are working very hard on getting guidance out to the states on some of these questions. Probably the biggest hurdle is the active and well-funded ISP lobby. They have been on the offensive in many states, and we think some of the lobbyists for the ISPs have been using arguments to sway legislators that we think are very disingenuous. For example, the argument that enacting privacy rules will prevent ISPs from sharing customer information with third parties like 911 operators in an emergency. Now, this is not true. In fact, federal law allows broadband providers to provide customer information to emergency responders, such as 911 operators, in order to respond to a user's call for emergency services. So there are lots of arguments like that out there, and so to combat this, we've put together a myth versus fact sheet that hopefully dispels some of the arguments that we think are disingenuous, and we hope to get that out to legislators as soon as we can. There are also some questions about preemption. The areas of legal uncertainty in the states, I think are important to pay attention to. When you use, for example, franchise agreements, it's not entirely clear if states, in fact, have the authority to regulate the practices of broadband providers under their right-of-way authority. There are some cases where states have attempted to do this, and using their right-of-way authority under 47 USC 253C, and the court found that they couldn't do so because the regulation has to be directly related to the regulation of rights of way. So that could be a barrier. There's research being done right now to determine whether there are perhaps provisions under the Telecom Act that allow states to regulate practices of providers pursuant to right-of-way authority, and we will also try to get that out to the states. You may also be considering including broadband providers and edge providers in one privacy bill. I've spoken to some legislators that have thought about this, and if you think that can pass, I think that would be fantastic, but know that you're inviting a bigger battle with companies like Google and Facebook, so it's worth approaching it with caution. They will throw as much money as possible at defeating bills like that. Let's see, there are also some states that are taking different approaches to pay for privacy, either only prohibiting take it or leave it, prohibiting surcharges, or prohibiting surcharges or discount. So I think California is looking at some provisions like that. Also, there's something called the Dormant Commerce Clause, which some people know about, some people don't. It's something that's sort of buried in the back of my brain. And looking into this, there is a chance that some of these regulations could raise interstate commerce concerns because, of course, people in different states talk to each other, and a mobile broadband customer can travel to another state and use their connection from there. And so you could see a reviewing court could consider the statute to have a non-facial effect on interstate commerce, maybe applying a more permissive balancing test. And so it could be argued that some statutes raise concerns of extraterritorial effects when applied to wireless carriers whose customers are traveling. So that's one challenge that could come up. We think that there are two ways that you can handle this, two sort of modifications to some of the bills. The first would be that the statute should specify that it only applies to the provision of bias to residents of the legislating state while they are physically located in that state. So just making it, crystal clear who is being covered by the bill. Second, the concerns about varying information collection practices and communications that occur between states with different regulations could be addressed by removing language requiring consent for collection and creation of a person's information. There's some bills that have done this, so consider removing that kind of language. And I think that's it for now. We are working, as I said, in coalition with many, many groups in Washington, including outside of Washington, the Digital Privacy Alliance, to name one, to make sure that you guys have sort of technologically correct, legally sound legislation that can withstand challenge. Thanks very much for listening. I hope that was helpful.
Great. Thank you very much, Michelle. And for those, we've got a few folks that joined us during the course of the presentation. We've got an incredible panel of experts on the technology and data space talking about ways they not only at a local level of taking efforts to protect privacy, but also in response to action that's happening at a national level. Peter, should we just hand over the conversation to Matt, or how do you want to go from here?
I will speak a little bit more about big data and just add a little bit to what Ann and Michelle referenced. So if you could hand it back to me and just give me back the screen, I'll put up just this placeholder PowerPoint and.
Hold on. Sorry about that.
It's not super important as long as get it to me.
There you go.
Great.
I'm going to take control of the screen right there.
I think it's but it's totally fine. I just wanted to talk briefly about big data, data brokers, and civil liberties, and talk about the business of data mining, how data is being used and misused, and talk about a couple of legislative options to give individuals more control over their data, including under the Illinois Right to Know Act, which we talked about a little bit, which Ann talked about, Representative Williams talked about a little bit earlier. So, I mean, we've all had the experience of receiving an email or mail or paper or some document from companies that we never didn't have any business with, but obviously got a company list, customer list from another company and reached out to us. But what if you had a medical procedure turned down because the hospital obtained some secret dossier on you, a profile on you that said that you were unlikely to pay for a procedure, or your insurance was unlikely to pay? Or if your child couldn't get into a college because the admissions office received some report that said that you're not likely to pay tuition in a timely manner, or you could take this farther and farther, you're not getting a job for a reason that you can't figure out. But again, a dossier was passed along from one of these data brokers to a decision maker that had a real concrete impact on your life. And that's the future that we're heading towards. There are a lot of big data brokers out there. There are, I think, 9 have been profiled in an FTC report 2014 that called for more transparency and accountability of data brokers. You may have heard of some of them: Axiom, CoreLogic, DataLogix, ID Analytics, Intellius. And these companies are in the business of basically tracking and connecting the different digital breadcrumb trails that you leave in your life, the things that you buy with your credit card or your debit card, to the things you search for on your web search engine, to the things that you browse or peruse on news sites and sports sites and other sites. And they are trying very hard to get a complete and fleshed out profile on every person alive. They have already built profiles for every American adult based on that digital breadcrumb trail. And there's the risks to your liberties and the risks to your constituents' civil liberties are not necessarily apparent when there's they are willingly making these purchases. They're willingly getting the benefit of using services like Facebook and Amazon and other services. They're getting those benefits and willingly signing off on that sort of data tracking for marketing purposes and so on and so forth. But the benefit of the bargain comes at a very high price. We entrust these companies with so many intimate details about our lives and activities, our photos, our location, health, relationships, our affiliations, and the benefits are apparent. But we aren't seeing how these dossiers are being used and how they can be used down the line. And there are a couple of risks that I wanted to point out. So first, the failure to regulate this data broker industry to at least cast a regulatory or legislative eye towards the industry of big data, which is largely just kind of transcends the existing regulations, because they do not want big profiles. They do not, operate, in the open. They operate in the back, and that's how they like it. The risks are real, and I'll highlight three. The first is the failure to regulate the collection of data by these private actors, these data brokers, makes it very hard to call for meaningful checks on governmental actors who would want to also collect and store the same type of data. So if I told you that a police department was making a registry of all Jewish people in a county in Illinois, or all Muslim people in a county in New York, that might arouse some concern that some civil liberties are being violated. But if that data could be purchased from a company like Axiom, the case or the argument against the government action becomes a lot tougher. Second, we allow these data brokers to collect this data and to store it and to build profiles on every person and to sell these profiles in bulk, and occasionally individually to folks, without much restriction. And what that does is we're allowing the creation of more and more attractive data sets to sit and rest in private hands for all sorts of actors, good and bad, and virtuous and ignoble, to seek. So there's a principle in cybersecurity, which is, of course, you never want to have the family jewels, the data family jewels in one place, because it makes a very attractive target, as companies that have been hit with data breaches are aware. But these data brokers have the family jewels, so to speak, the data family jewels on a lot of people. And the process is continuing as more and more, we talked about the Internet of Things earlier and how more and more data is being generated. These family jewels are being enhanced with even more data points and richer data points. So it becomes much harder to actually control that and protect against ever-increasing threats from all types of actors. Now, lastly, I want to point out that without sufficient transparency and notice of these entities' data collection practices, the public faces a really increasing risk of discrimination in decision-making in areas like employment, housing, lending, and education. When an organization makes a decision about something like an employment decision or housing decision or a schooling, education decision on the basis of a discriminatory, protected class or protected right, it's very obvious, very easy to, at least not easy, but you could vindicate that right by bringing a lawsuit, and it's clear what occurred. There's a neighborhood that the real estate agent is only bringing white people and refuses. That's obviously a federal issue. However, when everything is smokescreened through the activities of data brokers and companies that are in the big data world, they get organizations could make discriminatory decisions that are objectively defensible because they were through this very, very difficult to scrutinize and perhaps inscrutable activity of data brokers and secret profiles of American adults that, for the most part, American adults don't have access to, at least not unless the data brokers themselves have a policy and a procedure for those folks to get that data. One thing that I think is lost in this conversation is that companies do not owe us and owe citizens any rights beyond the rights that they say they will give us and the rights that we agree to have from them and give to them via contract. Americans aren't entitled to due process from a private company or a non-governmental actor that's collected their data. And companies aren't obligated or bound to uphold any of their users or their consumers' constitutional rights. There's nothing beyond an economic force that tells and instructs and informs what a company could do with a situation where they're faced with the disclosure of personal data to a governmental entity. If it makes economic sense, a company, and the company has the legal right to do so, there's no desire necessarily that comes from anywhere to vindicate a consumer's constitutional rights. I think the Apple encryption debate, where the FBI wanted Apple to unlock the iPhone for the San Bernardino attackers, cast that in really stark light. It looked a lot like Apple was really fighting for its iPhone users' rights, but there's a lot more at play. I mean, economically, there was a lot at stake because that FBI request sat on top of thousands of requests from law enforcement across the country asking Apple to do the same thing. So you should keep that in mind, and your constituents and all the policymakers on the phone should keep in mind that the really truly important thing is when it comes to companies and data brokers and other organizations collecting data, what they do with that data, it can often fall within the legal bounds and the terms of the end user license agreement or the privacy policies that customers and your constituents and Americans have agreed to in exchange for the product or the service. And that's what really drives the need for good, strong, common sense legislation and policy that Representative Williams has advocated and Michelle talked about, that really emphasizes two simple principles. Transparency. Be transparent about what you're doing with the data. And notice, when you're going to do something with the data that you didn't tell me you were going to do, at that point you should make sure that that notice is provided to the individual. Of course, the European GDPR is a whole different beast, but looking back at the FIPS that we talked about earlier, there's an element also of consent. If you want to go farther, at least require some consent from the individual, from the American, when their data is being repurposed, reused, and make sure that they have an opportunity to see what exactly a company has on them. And that's what I think the Right to Know Act, which went along with Representative Williams' sponsored geolocation bill, moved towards. I think these are the types of laws we need. These are the types of laws that we need to shift the balance back to protect consumers' privacy rights, particularly when faced with an administration that has already taken broad strides, as Michelle described, to diminish those rights. And it's a very tough time, but the fight is really going to be in the state houses. With that, I'd love to pass the baton on to Matt Erickson to give you a technologist's perspective on the impact to businesses as a result of privacy legislation and new laws that we've been talking about.
All right. Well, thank you. And thank you, everyone, for listening to us give this webinar. So as someone in the tech industry, we've noticed a few things. Customers are getting increasingly aware of their threats to privacy online. The issues that we're seeing from users reporting to us, they simply don't trust people on the internet anymore. There's more and more customers coming to, for example, us at Spider Oak. At Spider Oak, everything that a customer does is fully encrypted in a way that we can't recover. So it's great for privacy. Not everything can be done in that manner. There's very much a space for big data analytics-driven advertising on the web. And that can't be done if everything is fully encrypted. We're driving people away from the systems that industry is fighting to protect because they're not, consumers don't feel safe online anymore. One of the issues that holds is small and medium businesses trying to grow. A small tech startup, two guys in a garage, of which, as I've noted prior to the various chambers of the Illinois General Assembly, it was me at one point. When competing against big names, when you're in an industry where you cannot encrypt everything as simply a matter of course, what happens is nearly all your potential customers will go to the biggest names because those are the trustworthy names. People will go to Google. People will go to Facebook and Microsoft. And the thing is, a lot of these companies are actually fairly decent actors, but where it comes down to is because these are the defaults, because people trust them, people know them, and they know they're not going to have their data sharply abused. And when that happens, it's actually harder on small businesses to start. A lot of the complaints from the big data industry around these bills has been the impact on small, medium businesses, and I'm here to say that there's actually a detrimental effect to the current climate of distrust on small and medium businesses. Additionally, the compliance requirements from an actual implementation standpoint are not a big thing to get over. So let's talk about the Right to Know Act, which requires companies to disclose to whom they've essentially sold data to. For a simple business that doesn't have very much complexity in how that's structured, a form letter can suffice. A form letter is something that essentially somebody from the marketing staff and an admin to set up an autorespond email box can take care of rather quickly. In more complicated cases, where data is being shared in complex manners, nearly every business is going to have this information of whose data got sent where. That's going to be tracked and stored already in the database for accounting purposes. So in a grand majority of more complicated cases, all that's going to amount to is another database widget that can pull this report and provide it for a customer on demand. And that's not to mention that there are a lot of exemptions in the Right to Know Act for this. For example, companies are not required to report data that they share with third parties exclusively for the purposes of providing services to their customers, as long as these third parties then don't themselves turn around and sell the data. So for example, running a mailing list for your customers, you can use a third party for that. Using third-party web hosting, there's a lot of third-party services out there today that very much make it easier than ever before to start a business online and make it very easy to engage and delight customers that are perfectly fine and are not an issue under the Right to Know Act, under this transparency paradigm that the DPA supports. The reporting requirements are really meant to come down to when the data is sold or basically shared for reasons other than providing customers with services. And for Representative Williams' bill, the geolocation bill, all that's asking is for permission when the app starts up. It asks you if people can have their location stored and possibly shared. None of these are very high requirements. As Vice President of Engineering, it would come down to me to actually implement the requirements imposed by these laws, and it's not something that's very scary for us at all. And what it comes down to, as we've said earlier, is it's simply that the big data industry specifically is very interested in staying the big data industry. It's easier when you have a breach of customer trust to lock customers into you if they don't trust somebody new. And it's easier just to keep going on and pay no attention to have your customers pay no attention to the man behind the curtain. So as somebody in the tech industry, I've spoken with dozens of technologists around the city of Chicago. Chicago has a thriving tech scene centered around 1871 as a large incubator in the Merchandise Mart, and dozens of other incubators across the city specialize in either just incubation or bringing in disadvantaged communities or bringing in youth into the tech world. And everyone likes privacy. Everyone in the industry likes privacy. One of the bills that was passed had people who work at companies that were opposing the bill slipping in. It is really, the opposition that I've seen is really big business interests looking out for the interests of big business and not actually representing the tech industry, the tech scene, especially in Illinois, at large. And Peter?
Yeah, thanks, Matt. It's always great to have the perspective from someone in the industry, and I think everything Matt said has been borne out. Conversations I've had with folks in the tech industry, including my clients. I think there's this belief that privacy, or this not belief, it's almost like a false axiom that privacy stifles innovation. You want to have all the data out there and just a free-for-all. But that really reflects this dated zero-sum mindset that, you know, when one goes up, the other goes down. In fact, and I think this was very obvious from you know, what Matt was saying, is that there's the more sophisticated, and the true axiom is that privacy drives innovation. It forces innovators and tech companies to think creatively to find solutions that serve multiple functionalities, not just how can we use the data, what can we do with the data, but, you know, how can we also preserve the rights of the people who are giving us this personal data that we are using and are able to monetize. So that brings us, I think, full circle to the idea of just weaving the notions of transparency and making sure that there's some notice at a minimum in the context of legislation, that privacy legislation generally, and being familiar, even as legislators, as lawmakers, as policymakers, with other concepts that have been touched on, like privacy by design. You know, the principle that in the very design stage of a product or a service, you should be thinking not just how, you know, I'm an electrical engineer by training as an undergrad, so that's my degree. Engineers just want to get to the most efficient solution to the problem before them, and that doesn't necessarily require thinking and contemplating privacy rights. But privacy by design advocates not just focusing on the design of the product or the service, but being aware of transparency, notice, and the privacy rights of the end user during the early stage of development. So it's a lot that we've spoken a lot, we've shared a lot of information, and we've covered a ton of ground. It's obviously a very complex area, but it's not an area that is beyond mastery. And you know, the law is always going to be catching up with technology, but this is a really, really, really opportune time, especially given what's happening in the federal level for the state legislators and policymakers and folks who are active in the local level to play a role and really take the lead in an area that's so critical. And with that, I'll pass it back to Dave.
Great. Well, thank you, Peter. It's an incredible amount of information that all of you have shared, and I think given incredible insight into, the conditions of things, the challenges of ensuring privacy, particularly in the end user, and I started to chart some course onto what can be done, and particularly what can be done at the state level to ensure people's privacy. Got a few questions coming through, and we've got a little more time with these panelists today. So if folks haven't typed in their question, type in your question or raise your hand by clicking on the hand icon to direct questions to any of our panelists. We got a few questions that have come through, and I guess the first thing, kind of a summary, is where do policy leaders go to kind of synthesize and break down what are some of them? Where do you go to get the model policy to ensure privacy, particularly in the wake of efforts to deregulate and strip away some privacy protections that the president's executive action and congressional action? Can you name some sources of where people could go to get some, or share some sources to where policymakers, staff, other privacy advocates could turn to as a way of advancing these things in more state houses and chambers across the country?
Hi, this is Michelle. Yeah, I can try to address this, but I don't have a great answer. I know that there are a lot of advocacy organizations in Washington, D.C. that have considered doing this, and the Institute for Public Representation at Georgetown has taken a crack at creating some model privacy legislation related to broadband. I don't think it's released publicly yet. I think it's something that they are still vetting, but it should be very soon. They understand the sort of time urgency here. And I'd be happy to send it to you, Peter, or whomever, to make sure that it gets disseminated to people.
Yeah, that would be great. All I could add, I'm a practicing lawyer, but I also serve as a co-founding director of the Digital Privacy Alliance, but I also serve as the president of the Associate Board of the ACLU of Illinois, and I've worked on them legislative initiatives, and I know probably like a lot of other organizations, they're working on model response, model state legislative response to repeal the FCC privacy rules. It isn't public yet, but I think we could probably coordinate among the panelists could coordinate among ourselves and make them available to PLI or something, so that in a few days you could find some guidance there.
Sure. Right. I mean, this is obviously very technical in nature, but I think there's a growing desire among lots of people to figure out what can we do at our level, and I think earlier we heard from Representative Ann Williams talking about the work that she's doing in her respective state, and I think we talked about and really kind of concluded the fight to advance this is really going to happen in state chambers in many ways. So that'd be incredibly helpful. We'd be willing to distribute it to all the panelists. Got a question here that's coming in from Abby, and Abby, I'll just read through it because it's probably easier than just trying to summarize it. But, the Massachusetts Attorney General recently settled with a company, Copley, I believe that is, that was geofencing around abortion clinics in other states for pro-life organizational clients who then advertised alternatives to patients entering for a Planned Parenthood clinic. The company also claimed that they could send ads to patients for 30 days and discern individuals' age and gender. Is there any way to target companies like this to prevent them from engaging in these type of activities? Separately, in that case where it's a nonprofit organization advertising, but they are paying for some for-profit entity to do the work, the geofencing in this case, what are the would these actions be covered by the FTC because of the connections to that for-profit company? Or I guess maybe speaking to how do you govern around this? I think this starts opening this question, right? I mean, and I think all of you have talked about it, that it's so complex and things are divergent in each other. I mean, I think Abby raises a really good question. I don't know if any of you want to weigh in on
that. This is Peter. I could weigh in very briefly. It's a really good question, and yeah, it's a really interesting case. I'm not very familiar with the case. I know about this. I heard about the settlement recently, but I would say this is kind of the classic. And Michelle, please feel free to weigh in. The facts sound like the classic. Classic facts that would lead to potentially an FTC enforcement action. There was a company called Nomi that I believe in late 2012 or early 2013 began promoting this product that would basically be a MAC address sniffer that you would put in a department store, and every device has a unique MAC address. It's kind of like the physical address of a device. So every cell phone has a unique MAC address. Every connected device has that address. So what it would do is you could put this in your department store, and it would, as you would walk through, it would track, MAC address 12345, and then 3 days later, it would, ping for the same one, 12345, came through this section, the men's tie section, Tuesday at 3 p.m., and then again at Thursday at 3 p.m. And the promise was that, by sniffing these MAC addresses and not necessarily linking them to individuals, the retail store could learn wow, we have the same same person where the same phone is showing up every Tuesday and Thursday in the late afternoon in the tie section of Bloomingdale's or Nordstrom, and when we check our sales records, there's no sale. So why don't we put an extra retail person there? The FTC brought an enforcement action. Funnily enough, not because this was inherently an unfair business practice, but because actually Nomi on its website said that there was a way for folks to opt out of having their MAC addresses tracked in this manner, and in fact there was no way to opt out. As you enter the field that there's the fence that is established, the device would make a record of your MAC address one way or another unless you physically turned off your phone. So this does sound like something that would fall within the FTC's jurisdiction or ambit. It's really hard to say how active the FTC will be in enforcing privacy rights and going after unfair and deceptive business practices in the coming years in this administration. But to my ear, the facts that you described and the facts of this abortion geofencing settlement sound like what would be good for the FTC to go after. I don't know, Michelle, if you feel the same way or if you have anything to add.
I do think that it would be an interesting FTC case. I think it really highlights the importance not only of transparency, but also giving people actually choices and how their data is used and when it's used. One of the more interesting aspects of the geofencing case in Massachusetts, I think, is the fact that Copley challenged what the AG said through saying that they were exercising their free speech under the First Amendment. And I've heard this a lot. I've heard this speech frequently, the speech argument frequently when there's a privacy enforcement action or some kind of restraint. And, you know, I think it's an important argument to consider how you will challenge or you will push back on. I think, you know, free speech, of course, has some restrictions, some minor restrictions, and I think a person's privacy rights should be one of those pushback restrictions. And also, I do think that the case is just kind of horrible. You know, I mean, the violation that this agency seems really okay with having done makes it clear to me, at the very least, how important it is to place some restrictions, not just on advertisers like Copley, but data brokers, right, which is really what they are. There hasn't been a whole lot of real inquiry, except by the FTC, into data brokers, sort of how they're getting their information, where they're getting their information, how they're using it. There's a lot of opacity, despite what they might tell you because they have some website set up. There's a lot of opacity around how they use it, and I think that that's an important area that maybe state AGs should continue pushing on.
Great. I think I'm going to have to make this the last question coming for the time that we have allowed this afternoon. I guess, this is kind of like future forecasting. I guess in light of a lot of these actions, whether, I mean, deregulation efforts, heightened concern about privacy, do we anticipate a uptick on state action? I think we raised some of the concern. You step into some of this space, and some of the big data gatherers will come down with force in any attempt to touch. I don't know if you have any anecdotal or even concrete numbers of growth of state legislative action in this arena. Do you foresee more policymakers taking on this fight and demonstrating the courage to take on this fight, is given some of the powerful and very influential interests that will have a very strong opinion, probably against doing anything that curtails their ability to do what they're doing now?
This is Peter. I don't have any statistics. I would love to see some and see what the numbers actually reflect. But I did read an article. I think it was in the Times late March, early March, about this kind of the motion in the state houses in Illinois, California, Connecticut, New Mexico, Nebraska, maybe Virginia, were some of the states that have moved pretty swiftly to at least, you know, try to get bills done and in motion that come up and fill the vacuum that I think is growing on the federal level. But I don't know if Representative Williams or Michelle or Matt have anything else in terms of statistics or other state action.
Well, I think this is David. I think it's definitely, reaching out to our partners at the National Council of State Legislature and others that can provide some tracking tool resources. I think this is definitely something that the more, all this information being packaged in such a way for policy leaders that are interested in tackling this. And maybe a project that PLI will, can lend some support and help and gather. With that, I just want to take time. I don't think we've got any additional questions. I want to thank our panelists. This is some very complex and complicated policy, probably maybe one of the most complicated ones that we've engaged in, and folks across the country spending this time with us, trying to digest it, and definitely kind of see where they respectively fit into it. I want to appreciate everyone for attending, but particularly our panelists, Peter Hanna, Michelle Demouy, Representative Williams, and Matt Erickson, for taking time out of your busy afternoons to be with us. Thank you very much. And Peter, may I give you the last word, or any of you, the last word?
You know what? I'll take the last word. Sorry. I was just going to say one thing. Yeah,
Thanks.
I just wanted to remind people that, I know Representative Williams mentioned that it's bipartisan, but in fact it truly is. The CRA, the Congressional Review Act that repealed the broadband privacy rules, there were 15, I think, Republicans that voted against that. And many of them stood up and spoke out in favor of privacy and indicated that they had heard from their constituents. So I think not only is that true that this is bipartisan, but there is a huge appetite in the public for restrictions, and I think you have a lot of support among regular folks to enact protections that the federal government just won't.
Well, Michelle, we'll leave it at that. Thank you everybody for taking time to be with us. Stay tuned for future policy discussions like the one that we had this afternoon. Look for the Public Leadership Institute alerts that go out for these sessions that happen every 2 weeks. This is put this into action. Feel free to pull on the expertise of the panelists, and I think based on some of the interest that's been expressed by some of those who are joining us, see if we can package some additional resources to help guide your policy leadership on these fronts. Thank you again, everybody.
Thank you.